So I guess it's the same batch which was there yesterday. Any newcomer today?
Yes, sir, all the people are same.
All the people are there. Okay, fair enough. So yesterday we covered some recent cases in CIRP process, right? In a CD. And as all of you must have also read that Bhushan Steel is also reserved yesterday. Let's see how it turns up. Today we will discuss about personal guarantors. And taking clue from yesterday's class, I think since we don't have a lot of participation, I have increased the number of cases little bit. Uh, Now our cases. So yesterday we did 9. Today I have around 12 cases which we can cover. This is recent judgments of personal guarantor. Personal guarantors, they have recently taken off, right? So I'm assuming many of you must have also got the cases of PG to CD, though they're not many in number. So if you just want to have a small statistics on what kind of numbers are we talking about, there is a on IBBA website. This is the status which is available, as on 3 months back. So total of 4,203 applications have been filed. Let's say 4,000, right? 4,200 applications have been filed, out of which and RPs were appointed. See, in this case, RPs are appointed right away, right? It's not an adjudicating thing. So on filing itself, they will ask the RP to file a report under section 99. Correct? After the appointment of the RP, 135 cases have been withdrawn, 162 taken up and all. But this is your major statistics that 4,000 PIRP cases have been filed, in which 1,832 RPs have been appointed. And we have also seen that, at times banks takes personal guarantee of everyone. I mean, 1, 2, 3, 4, 5 directors or promoters, and then they file also the cases accordingly. So if they're filing against one, they will file against all. So in a way, it might not be separate CDs altogether always. It might be a combination. So there might be 3 guarantors to the same debt or 4 guarantors to the same debt. So it includes all those cases as well. Out of 664 admitted PIRPs, 196 closed, 12 withdrawn, all that story. But majorly what we need to understand, approximately 600, 700 cases have been admitted. That's all. Here, some are, and anyone knows where do we file these cases? Do we file at NCLT or bankruptcy or DRT? Where do we file these cases? Anyone?
No, NCLT only.
Rahul is saying NCLT only. Okay. And we don't file at DRT, sir?
I think so. Now,
Okay.
if the CIRP is at NCLT, then we'll file PG also at NCLT
Okay. And if not?
and then at DRT.
If not, then we have to go to DRT, is it?
Yes.
Okay. So, we'll be discussing one of case law like this also, which might not be the right stand as on today. So far NCLT, so that case law is also coming up, where NCLT Kolkata had said that if anything is pending, etc., then you come to NCLT. If not, then you have to go to DRT. But there are cases which have been filed in DRT. So certainly, this is the status. If I think I can show you. Yes. So in DRT also people have filed bankruptcy also. Bankruptcy, total 63 bankruptcies have been filed. 2 of the applications are filed by debtor and 61 applications have been filed by creditor. When it comes to PG, 90% of the applications are filed under 95, not under 94. That is your, creditors are filing it. In DRT, there is one application of bankruptcy also filed at DRT Chennai, but mostly they are at NCL. Fine. I'll close the statistics for the timing. We'll straight away come to our case laws. And the case law is here. Okay. Let's start the case law, sir. And in case laws also, please feel free to stop me, disturb me, whatever, we can discuss it. If you have some of your personal experiences, something like that, you can stop me. We'll work it out for 3 hours, right? So first case was what we are discussing today is Mukund Chaudhary versus Union of India. Uh, this case has reached till Supreme Court, so went to NCLT, went to NCLAT, and then on 14th February 2025, this is Honorable SCS also gave their decision. What is the decision here? So first let me give you the facts and then we'll tell you the decision. Now, a writ petition before SC was filed challenging the constitutional validity. Now, in this case, what actually happened is the PIRP, as we know, is a 160-day time period. Correct? Now, there are a lot of times when 180 days is not, we don't get repayment plans in 180 days. Or at times it's not, we are not able to trace the person. Or at times COC doesn't take a decision. They say first we need valuer, we need to appoint, whatever, asset tracing agency, etc., and then we will take a call. Suppose they say we don't, 180 days is not enough. In this case also, COC was not able to take a decision within 180 days and RP filed an application to NCLT bench 3 saying that please allow us extension akin to CIRP. Now what happens is NCLAT gave that, so this is that section 101 which is under challenge. Moratorium referred to in section 1 shall cease to have effect at the end of the period of 180 days beginning with the date of admission. Correct? Now, number of days is given. It's not like CIRP where CIRP says till it continues, section 14 continues. Here 101 continues only for 180 days. Now RP filed it, COC approved it. They said they went to NCLT saying, Lords, kindly allow extension. Now, extension was allowed. Extension was allowed by NCLT, but they said we are not extending the moratorium. Because moratorium is clearly mentioned only 180 days, there is no extension here. Commercial wisdom not come into it. Now, obviously, they went to NCLAT, they said, what is the meaning of CIRP if there is no more, PIRP if there is no moratorium. NCLAT also rejected this, went to Supreme Court. Supreme Court also said 180-day moratorium prescribed in section 102 is final, cannot be extended. Scheme under part 3 is structurally different or distinct from part 2 and the moratorium timeline serves different objectives. So they said that CIRP has different purpose, PIRP has different purpose. If you are not taking a decision, that is your problem. You have to take it within 180 days or moratorium is not available. You can finish the CIRP, no problem. You don't have. So this was Mukund Chaudhary versus Union of India. So please remember, as an RP, if you become an RP of a PG case, should ensure that it is getting over within 6 months. There is no extension of moratorium applicable, and your repayment plan might go for a toss. So this was in Mukund Chaudhary versus Union of India. Any question here in this case? Any views?
No, sir, if
If
a
no,
case is allotted to you and you have submitted application under section 95, your report,
99. Report is 99.
99, yes.
Yes.
Then what is the date of that commencement of this process?
Commencement is under section 100, sir.
Hmm.
So when we get the order
When
under
the
section
moratorium will
100,
start?
on the date of admission.
Admission, okay.
So in PIRP, we know that there are two kind of moratorium, correct? One is interim moratorium, which starts on either 94 or 95 filing, and another one starts on, so it gets over on 100, and on 100 there is a new moratorium which starts, which is valid for 180 days.
Okay, thank you.
Okay, so 180 days as RP, please ensure there is only 180 days for moratorium. Extension is possible. Try not to take that, I mean, this is the only thing you can actually push here. Otherwise, RP is not supposed to push anything on anyone. There is no takeover. There is no IRP to RP, nothing. There is one single person who gets a plan. If the plan is fine, people accept it, submit it. Simple. Okay. Now we'll go to our second case law. Second case law is Anita Goel versus ITCL. In this case, what happened is this obviously reached to anklet, and I think it will be going a bit over also. Now, this is about uh, jurisdiction, what we were discussing in the beginning, right? That whether we can go to DRT or the NCLT. Now, this question is going on for last, I think, 5 years. This PG was introduced in, when, right? 1st December 2019. It's been 6 years, or almost going to be 6 years. And we were still discussing this, that jurisdiction, where is the jurisdiction? So this case is Anita Goel versus ITCL. And, recently on 23rd Jan, this order has come from NCLAT. It says, here the applicant argued that since no CIRP was pending against the CD, the application should be heard by DRT and not by the NCLT. Correct? And obviously, we know a case law also got in this where Kolkata bench had given such order, right? Now, issue was whether an application under Section 95 of the IBC against a PG is maintainable before the NCLT in the absence of any CIRP or liquidation proceeding. So, answer you would be yes or no if we decide on that. Here, the appellant relied on Section 179, read with Section 79, which grants jurisdiction to DRT. Right? Because of this only, they say no individual insolvency DRT as the jurisdiction. And opposing view was 60/1, which explicitly vests jurisdiction in NCLT over PG to CD. Now, both these sections are always at contradiction, and that's what people challenge. Here, Enclate has finally, this is as on today, this is the law which stands as on today. Enclate rejected the appellant's argument and reaffirmed that NCLT has jurisdiction under Section 60/1 to entertain an application against a PG, even in the absence of CIRP or liquidation proceedings against the CD. So tribunal actually criticized the view. I mean, they said that view is not correct. And the NCLT Kolkata in Tata Capital versus Arjun Agarwal had said that if nothing is pending, if CIRP liquidation has not touched the cornerstone of NCLT, then PG to CD also will only go to DRT, not to NCLT. In this case, Anita Goel versus RTCL, NCLAT has very clarified, no, you can come to NCLT. Fine. So it removes lingering doubt regarding jurisdiction in personal guarantees, and it reaffirms the primacy of 60/1. Creditors can proceed against the PG directly before the NCLT. And jurisdiction does not depend on the pending CIRP or liquidation. But Now, anyone would like to answer one question? If suppose one guarantor has given guarantee to two different companies, one is based in Delhi and one is based in let's say Mumbai, where will the proceeding starts? Any idea?
If it is regarding two different company, it depends upon against which company you are starting the proceeding.
I'm not starting against the company, sir. I'm starting against the PG.
Okay. PG, personal guarantor. You are not starting. Personal guarantee has given guarantee to
Guarantee of two
different.
different companies, and let's say both of them are defaulting. Then where do you go?
If he has signed the guarantee documents at different places, then at those places the jurisdiction will apply.
Oh, you are saying signing of the place is important.
Yes.
Basically, the personal guarantor.
No, sir.
It
How do we
depends
start
upon the personal
NCLT? How do we decide jurisdiction of NCLT in CIRP cases?
It depends upon at which place
Registered
the person
address.
resides.
Registered address, right? Of the
Yes.
CD. Correct.
Okay, correct.
So in our case, what happens? Now we have two registered address, one in Delhi, one in Mumbai. One company A, another company B. Where can you start? And let's say the personal guarantor stays in Hyderabad, C. Then where can you start?
Any other place depends upon which proceeding is started first.
Sir, no proceeding has started. We are starting. That is the question.
That means that at both places it can be started.
You mean either?
Even either, yes.
Okay. Any other view? Sashiji, yes. Where can you start these proceedings? Devangji is silent today. Devangji, where can we start? In my view also, you can start at any place because it does not restrict. If the personal guarantee is properly invoked, wherever you are invoking the personal guarantee properly, you can. And if there are two different people, they can invoke at two different places also. But then obviously, wherever it is admitted first, second will stop, correct? So either or, sir.
Yes, so in whichever entity it is there, it is ideal to begin over there. If the company is maybe one company is in Mumbai, another is in Delhi, if the respective jurisdiction is Mumbai bench, so for that particular company, it is better to initiate in Mumbai. For Delhi company, if you are initiating, it is better to initiate in Delhi. And of course,
No, sir.
in other circumstances,
There is nothing called better in law, sir. It's either or. Either you can do it or you cannot do it. So our question is, can you start in Delhi or can you start in Mumbai? Answer is yes, we can start at either places. Because there also there is
thank
a
you.
default, here also there is a default. And you can also start, in my view, you can start at the address of his Aadhaar also. So suppose the Aadhaar address is of Hyderabad, you can start at Hyderabad as well. Doesn't have to be NCLT Mumbai or NCLT Delhi in such case. Since no CIRP has started. But what will happen when CIRP starts? Then this application will also be transferred. So since it will be transferred, why do you want, to go through all that problem? You might as well take a decision on where you are planning to start CIRP, if any, or where there is more chances of starting, you start your proceedings there. Because once it starts, then it is a process in RAM, right? Anywhere, everywhere. There is no FCOC kind of thing here. Every creditor is a creditor. Okay. So, so that might not be really that big importance for an RP, but as an advocate, you may need, where the jurisdiction comes into picture. This is our third case law. Indian Bank versus K. Tirumurhan. It's Anclet Chennai bench. 4th of June is the case. Now, what happens in this case is Indian Bank filed an application under 95 before Chennai, seeking to initiate that they have executed a personal guarantee for creditors. However, prior to this application, another financial creditor, right, IDBI trusteeship, has already initiated an application. Now, our right now problem was, I mean, this is a little older case, 2 years back. We don't know whether proceedings have started or not. See, in a CIRP, you just log into IBPI website and you can see corporate processes, correct? And then you'll file or not file. It's pretty easy to identify. For personal guarantor, it is still a very big lacuna. We don't know whether insolvency has started against a company or not. Where do you find it? Unless that particular person says, or you check newspaper of every corner of the country. Otherwise, there is no way right now, even right now, to know whether Section 95 has been filed against someone or not, even till date. So obviously, IDBI trusteeship ended up filing IDBI trusteeship had already filed and Indian Bank filed it. Now, interesting part is if they have already filed and yours is pending, it's okay. You can hold your horses, right? There is interim moratorium. But what Indian Bank did is they went to Anclet. Now, NCLT had dismissed their application. They said it's infractus, stating that the matter was already sub judice due to pending application. So please go to some other place, or please hold your horses, or if the RP is appointed, then you file your case there. Indian Bank filed an appeal against this. Don't know what kind of advisors they have or what might be the thought process, but they went to Anclet. Here, Anclet, obviously they're challenging the order, right? Here, the issues framed were whether the NCLT was justified in dismissing Indian Bank's application under 95 as infractors due to a pending proceedings against the same personal guarantee. And whether Section 96 of the IBC, which bars multiple proceedings against the same guarantor, is that correct interpretation? Can no other proceeding against that same debt can be proceeded or not? So it's more like understanding what is interim moratorium all about. Okay. Now here the legal framework, just to give a little background. Section 95 allows a financial creditor to initiate insolvency resolution process. 96(1) says that upon filing of an application under 95, an interim moratorium commences and no fresh application can be filed against the same personal guarantor until the proceedings are disposed of. Now, this law is so clear. There is, I don't know what doubt Indian Bank had in this case. They and they still went to in appeal to NCLAT Chennai. We have two NCLATs, right? One in Delhi, one in Chennai. So South NCLTs all go to downstairs. So Anclet referred to its prior decision in Indian Bank versus T. Prabhakar, which was in April 2025, had addressed the same issue and it resulted in dismissal based on Section 96. I said there's already a order, please refer that, and it cannot be done. Judgment is they dismiss the appeal. Section 96 creates an express bar against the filing of multiple applications, and Tribunal noted that once one creditor is invoked and those proceedings are pending, no other creditor can initiate a fresh proceeding against the same section. And you can start it, no doubt, but once the prior one is concluded. Fine. So you take a leave, your lawyer take a leave, say that fine, if those does not start or something happen, then we reserve our right to restart it. So that is the ideal situation, and that's what the judgment also says. So as an RP, what is our takeaway? Even if by mistake, let us say you have been appointed as 99, it's your duty to identify whether those application, any other application is pending or not prior to you. If any other application is pending, you will have to mention to the court in your report under 99 that so and so is pending. You also inform the court in case those other people are not able to inform you. Is that fine? Any question regarding this, or we can move on? No questions? Because if no questions, then my PPT will be over in 1.5 hours only, not 3 hours. See, and in PG, there are not so many cases are not there. They are very simple proceedings. Either you give a plan or you don't give a plan. You give a plan, we'll consider it. You don't give a plan, we go for bankruptcy. Right? Then that is why if you see there is no minimum fees prescribed. Bankers say that RP you don't have much work to do and take 10-15,000 per month and that's all. I've heard there are stories that people are even taking assignments for 10,000 and 15,000 in jurisdictions like Jaipur, etc. Or at least a lump sum fees. Lump sum fees, I personally have experienced. They offer 1 lakh lump sum to the RP to do one PG case. So those stories are also there. Maybe because bankers think that there is no much recovery possible out of it, then why do even put so much money behind it? Also, the IVBI has kept it as a stepson and no minimum fees is prescribed for this period, for this process. So I guess with this judgment, no other comment, then I'll go to my next judgment, that is State Bank of India versus Deepak Kumar Singhal. Now, in this case, what happened? We have covered 3 case laws. Fourth is State Bank of India versus SBI. And State Bank of India was the first bank, actually bank where a lot of cases are being pushed by SBI in different forms. Even in the beginning, it was State Bank of India which was taking lead in filing. This case, it was decided on 28th of February at Anklet, Delhi. Here facts are, State Bank of India extended financial facilities to LML Limited, which was the corporate debtor. Deepak Kumar Singhania executed a deed of guarantee. Now, this will be a deed of guarantee where the wordings are so important. So you will see the fun of using the right word and how not using the right word can change your entire case. So Deepak Kumar Singhania, who is the respondent personal guarantor, he executed a deed of guarantee dated 28 March 2005. Right? Almost 18, 19 years old. Along with 2 other personal guarantors in favor of SBI, and a multi-party agreement was executed. Now here, SBI filed application under section 19 of DRT and this was pending disposal. Now, obviously it's 2005, right? So they must have been pursuing it at NCL, at DRT. Now when, after the Arjika case, when, there is no bar on our PG to CD cases, they came to our, what you call, NCL. With respect to the CD, an order of liquidation had already been passed. Okay, because they were there. They said, okay, fine, now liquidation is there, we'll go to NCL. There we might get a faster result. Here what happened is, on 4/5/2022, see the liquidation had finished in 18. After 4 years, they realize that, now the village Arjika is there, why don't we try this route? So SBI, they issued a demand notice. See, everywhere we have to issue demand notice, right? In CIRP, under Section 8, we have to issue for the, what do you call, OC. Here, under Rule 7, we have to issue a demand notice. They issued a demand notice saying, what they said? Calling upon the respondent to make a payment of 125 crores. Now, an application, obviously, this was not paid. Application under 95 was filed. The application was filed in 28th of May. That means within 24 days they filed it. So they must have given 2 weeks time, 10 days time. If it is not followed, you file the application. Now, in this case, date of default has been mentioned as 1st 2017. When AA appointed the RP by order of 2/1/24, right? You can see after, how many days. And these are not actually days, it's actually 2 years. So after 2 years, this person was appointed RP for 99 reports. On 28/11/2024, that is after 11 months, the impugned order was passed by AA rejecting 95 application, holding that applicant having failed to invoke the guarantee, the application filed under 95 does not satisfy the mandatory prerequisite for issuing a legally valid demand notice for such filing of application. Application 95 was held as non-maintainable and dismissed. It was held that the respondent is not a guarantor as defined in rule so and so rule. Right? Agreed by this, obviously SBI went into the challenge. Now, what does RPs will have to learn here? What is our takeaway here? Obviously, RP must have said it should be admitted, isn't it? Because if you say it should not be admitted, then how will you get cases? So, what as an RP can you do? Do you have any much things to say? As you know, your section 99 has to be, see, you can't be expected to be the super expert in every law. Take assistance of your legal team wherever possible, but clarify these, touch upon these points, at least what we are discussing, that there is some thing already pending, whether you made effort to check it or not. Now, one of the RP was suspended only because of, what? Only because of non-checking of delivery of the notice. Whether that letter, that demand note was delivered properly or not, on that basis, this person got suspended for 2 months. And this person was attaining 70 years of age. So only 2 months were left anyways. So as RP, when you're filing 99, it's though they say it's only recommendatory, but it does come to bite you if there are some adverse comments if they are made against you. So needs to be noted. Here in this case, SBI went in appeal. They said we have done everything as per law. How can it be rejected? And that too reject after 3 years. They filed in, you can see, they filed on 30th April 2022, correct? And this was rejected in, when it was 28/11/2024. After 2 years, you are saying, okay, now we had not invoked it properly. They went into appeal. What happened in appeal? Appeal, the issue which was framed was whether the demand notice issued under Rule 7(1) of the PGIP rule can be considered as notice, invocation of notice. So invocation, is it equal to the demand notice or not? I mean, that is the essential thing, right? SBI is saying if we are giving a demand notice, it is as good as invocation only. What else? And the guarantor is saying, no, there is no invocation. You have to do invocation, then only demand notice can come. After invocation, you can do demand, no problem. But without invocation, how can you demand? So that was the issue which was to be decided by NCLAT. Here what has happened is appellant argued that invocation of guarantee is only relevant under section 94 as form A specifically asks for it. In contrast, form B does not explicitly ask for it. So we did not do invocation, we straight away send demand notice. There is no problem. And it is an implied invocation since it doesn't require, any other thing. Now, but obviously respondent said, no, this is not correct. Learned counsel for the respondent referred to NCLAT judgment in Pooja Ramesh Singh versus SBI, same people, where the tribunal held that default by the guarantor arises only after the guarantee has been invoked. And that is why, please remember, this word is pretty important. You cannot say that I have sent a demand notice, this is as good as invocation. No, it has to be invoked in the manner it is agreed on in the guarantee deed itself. In case it is not mentioned, still it has to be very clearly on top of it. It should be, identified that we are invoking guarantee against you now. If it is not legally or validly invoked, it will not be taken. That's what respondent said. Now, in the demand guarantee, default is deemed to occur only when a demand notice is issued and the guarantor fails to pay within the prescribed. In that case, SBI invoked the guarantee on 1st 10 2020 and default must have occurred on 8 10 2020. You know, right, where we are playing in this case. We are playing on the limitation. Else we want to show that, 3 years have, are there, so it cannot be invoked. Correct? Since the default date fell within the Section 10A moratorium period related to COVID, Section 7 application was brought. Adjudicatory authority had wrongly admitted their Section 7 based on this terms of guarantee. Now, I think there is a mix here. So this has to be changed. Definition of guarantor, we have learned in Rule 3.1 is a personal guarantor to a CD in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So even making 99% payment will not help unless it is that the threshold is clearing. There are a lot of smart people who are only paying X amount so that the threshold comes down. Otherwise, let it be. So both conditions have to be cumulative. It has been held that a personal guarantor becomes a debtor only when guarantee is invoked. So till it is invoked, nothing doing. Hence, the decision was appellate tribunal was not persuaded to accept that we don't need to issue demand repayment is good enough and it should be treated as invoking it. This was rejected. Hence, as an RP, what is your takeaway? Your takeaway can only be that whenever you're filing your report under 99, see the report under 99 has 10 columns, right? 99, 1, 2, 3, 4, 10 things you need to check. In which one of the thing is whether the guarantee was properly invoked or not within time. So always ensure your 99 report is as comprehensive as possible. Obviously, no order. Important. Any question here? Anyone has? Or if no question, then no questions. Okay. Fair enough. So we'll do one more case. After that we'll take a break because it's going too fast. Otherwise, it'll has to be retained, right? So my next case law is this one. Rakesh Bainot versus Gurdas Agro. This was again delivered in April, sometime back, and around 4 months. In this case, Rakesh Bainot is about that 138 bouncing, etc. Right? In this case, and this is a Supreme Court order, Gurdas Agro Private Limited filed a complaint under 138 of the Negotiable Instrument Act against Arjun Mall Retail Private Limited through its director, Kiran Bainot, Rakesh Bainot, and Arjun Bainot. Right? It was alleged in the complaint that the accused issued 4 checks of 50 lakhs each. Now, checks were presented, they were bounced. Obviously, this problem is now going to come up. Now, when 38 is there, what happens? You know what is Section 138 proceedings, right? Within 1 month, if you are asking them, 15 days plus 15-day notice, within 1 month, you ask them, they have to pay it. If they don't pay it, then there is a jail term which is waiting, and either you go for jail term or you make the payment, right? That is normally check bouncing case, what we know. Now, during the pendency of these proceedings under 138, this applicant, he was advised by his lawyers that why don't you file a 94? You say the debts are there. I'm not in a position to pay my debts, so I will file my personal insurance. I'll declare my personal insurance. So X section 94 was filed. On the day the case is filed, what happens? Interim moratorium is applied, right? Is applicable. So they went to NCLT Chandigarh for personal insolvency. Wife also filed a similar application, and they said now this is pending. Now you have to stop the proceedings under 138. Correct? And not only 138, similar proceeding. Anywhere it is pending, they will send a mail to everyone that now we are under moratorium. Don't start the process. Your jurisdiction is over. Here, pending the insolvency proceedings, the appellant move an application before the trial court for adjourning. Obviously, what was supposed to happen? Trial court. See, trial courts and a tribunal, I think yesterday I had given that hint to you, right? Trial courts, they really don't bother. They say no, until unless it's too small a court, they try to continue. They say no, we are the courts. We are not tribunals, we are courts, we are here to uphold the justice. Trial court rejected this application. When trial court rejects, what do? You go to High Court. They went to Punjab and Haryana High Court, and 482 is a section which is for quashing the FIRs and other proceedings, etc. So they said it should be closed, and it should not be proceeded with. Now, by order dated so and so, this petition also was dismissed by the High Court. High Court also said nothing doing. Section 138 proceedings cannot be stayed. Sorry, you will have to be proceeded with. 94 moratorium, etc. does not come into the way. That's what High Court said. Now what will happen? Obviously, they'll come to Supreme Court. Now they came to Supreme Court. Whether the proceedings, so this was the issue framed by Supreme Court, whether the proceedings initiated against the PG in 138 read with 141 should be stayed upon filing application under section 94. 141 is actually, see, so 131 is against individuals, and 141 is when, when the company is there and you are signing on behalf of company, etc. That is 141. So whether these proceedings should be stayed or should not be stayed. Decision, here's the decision of Honorable Supreme Court. It said legislative intent behind IBC is to provide a structured framework for the resolution of CD's financial distress. and thereby facilitating their rehabilitation and ensuring maximization of asset value. They said from the provisions of Section 14, Section 94, from these different provisions, it is clear that corporate person includes a company and a limited liability partner. However, there is a subtle difference when it comes to the protection of directors and the partners. When it is directors and partners, then there is a difference. In case of partnership firm, the interim moratorium protects only the firm, not only the firm, but also the partners. But partnership is not yet started, right? We know that it is only PG to CD. In case of a company, such protection is available only to the company and not to its directors. And they said apart, the object of interim moratorium can be no different from the moratorium specified under Section 14. It is also clear that Section 14, legal action during the period of moratorium is not available to the surety, to a personal guarantor. So they said all the debts in respect, the word of use, all the debts or in respect of the debt is not without a purpose. Moratorium is intended to offer protection only against civil claims to recover the debt. And civil claims, see, 138 is a partially criminal, partially civil, right? So quasi criminal, we call it. So 138 is a criminal process. Suppose he is doing murder. Now, murder doesn't mean Section 14 will protect him, correct? Same way, Section 138 is a kind of criminal proceeding. So 138 kind of proceedings will not stop. Only the civil debt, which is not with fraud, etc., only that will be stayed. As they said, purpose of interim moratorium contemplated is to be derived from the object, which is not to stall the proceedings unrelated to the recovery of debt. Protection is not available against the penal actions. So 138 is not only recovery, right? It's not only check, you return it. It's also a crime. And the crime is minimum 1 month jail also is prescribed very well. So they said when jail is there, it is a criminal proceeding. We should not quash it just because 96 is pending here. So this is just more details on that upon the application being admitted, moratorium provisions under IBC offers protection only to the CD. CD do not extend protection against civil liability to criminal liability to personal guarantors by specific exclusion. Interim moratorium and the moratorium under 101 are designed to offer a breathing space to the not to the CD, it's actually personal guarantor, I think. So a wrongly designed PPT, allowing them to recognize their financial affairs without the immediate threat of creditor action. However, moratorium is not intended to shield individuals from personal criminal liabilities arising from their actions outside the scope of corporate debt restructuring. Fine. So I guess this is over. And okay, I think this is a decent word to note. It says no, any legal action or proceeding should be stayed. Now, any they said does not mean every. Any does not mean every. It only says if it is in respect to debt, personal debt, which is see, check bouncing is a problem. Check why you issued. If there was a debt you are not able to pay, it's fine. It's a civil proceeding. 96 will apply. But if you have issued the check, then it cannot be stayed. Then that will continue. So if you are advising your customers, please ask them not to issue checks. That's all I can say as a takeaway. Statutory liability, it continues. Scope and nature of proceeding under IBC may result in extinguishment of the actual debt by restructuring or through the process of liquidation. but such extinguishment will not absolve its directors from the criminal liability. So there is a pretty clear difference when it comes to civil and criminal law. So I guess with this, since no one else is talking, we'll take a break here. We have come almost halfway. Maybe we'll join at 4:30. And Anjali ji, is that okay?
Okay, sir.
Yes. So we'll join in 20 minutes, let's say 20, 25 minutes. And there are around 6 cases left. Where we will discuss, whether High Court can quash proceedings, what should be the threshold for applying for a PG cases. And after that, last half an hour, maybe we can keep for if you have any personal cases where you have something to discuss, you are already facing some difficulty, if you'd like to discuss, maybe we can discuss that for fine. So we'll assemble in 20 minutes. Huh? Thank you.
मुझे तुमसे प्यार है इतना
Hi, can we start now? I hope people are back.
Yes, sure, sir.
Thank you, Rahulji. So we have finished till, I think, 6 cases. Mukund Chaudhary, where we discussed whether, moratorium can be extended beyond 180 days. Answer was no. Anita Goel case, NCLAT, where jurisdiction was discussed. And as it stands today, jurisdiction is of NCLT. You don't need to go to DRT, even if there is no CIRP or liquidation pending. Then we went to whether simultaneous application can be filed or not, and answer is no. If there is something already pending, then the simultaneously it should not proceed. Right? Uh, any idea why do they file this? Why do they do this? That file it, and even if you are aware that it is pending, do you file it? I think they file it with the threat of limitation. That if we don't file it, 3 years is over, then what do we do? Right? That is why many people end up filing that, okay, let that 3 year problem is not there. If it is withdrawn after that, it can be changed. Devangji, you were saying something, sir? No. Okay. So, I mean, I think that's the primary reason. But in my as a legal view, I feel if there's something pending, now that since you could not proceed against that person, you can exclude that much period from your limitation. So there is no need of filing it as long as you are aware that it is already filed. Fine. After that, we went to Deepak Kumar Singhania versus SBI matter, where we learned that proper word invocation has to be there. Where we learned that demand notice is not equal to invocation. Correct? These are two different things and should be clearly executed. I think after that we learned about Rakesh Behnot case where we said criminal cases will not be stayed. Section 138, 141, all those cannot be stayed. And only in respect of civil debts, these proceedings will come to a halt. Fine. This was District Court, Punjab and Haryana Court, even Supreme Court has said, no, 138 is not a thing which should be stayed. Okay. Now coming to our, have we done this Farooq Ali case? No. This we have not done. So here we have our next case, which is Bank of Baroda versus Farooq Ali Khan and others. This is again a case of Supreme Court, decided in February 2025. Here, Mr. Farooq Ali was a promoter and director of Associate Decors, which I will learn from a consortium of banks, and most probably Bank of Baroda was the lead one. Mr. Khan executed a personal guarantee in 2014. Now, following defaults by the corporate debtor and invocation of the guarantee, a demand notice was issued. So here there was no problem of invocation, etc., right? In 22nd February 21, Bank of Baroda filed this application under 95. AA on 16th of February, you can see that it's after 3 years. So 22nd February and 16th February. So it took almost 3 years. But this is not NCLT's problem because these matters were pending at at Supreme Court due to that Dilip Jiwarjika thing. This must have taken time, right? Otherwise, there's no reason that it should take 3 years. They appointed a RP and directed to submit a report under 99. Now, Mr. Khan, he filed a writ petition under 226. Right? We file under 32 or 230 or 226 at High Court. In High Court, Karnataka High Court, he said claiming that his personal guarantee liability had been waived and seeking to quash the insolvency process. So 226 is a writ jurisdiction, right? You say that writ of mandamus, etc., be done. High Court interestingly accepted that. High Court granted the relief, and then NCLT disposed of the proceedings on 19th of June 2024, because High Court has already given that issue. Obviously, when High Court is saying something, everywhere in our court, it clearly says that it should, our AA is NCLT, then go to NCLAT, and straight away we go to Supreme Court. There is nobody in between, and High Court should also not come. But obviously, 226 is another Brahmastra which our High Courts have. So now Supreme Court had to decide whether High Court under 226 prematurely halt these personal insolvency proceedings under IBC. And can they adjudicate on issues like waiver or limitation, etc., before this adjudicatory process is played out? So now, to just touch upon the legal framework again, Section 95 to 100, it regulates initiation, appointment, RP report, and the decision. Correct? 94, 95 admission, 96 moratorium, 97 you appoint him, 99 you tell the person to file a report, and after the filing there is adjudication, you admit or reject whatever you want, right? Now, Supreme Court and Devvart has already said that 94 to 95 are non-adjudication, and hence RP report is merely recommendatory. No issues so far, right? Supreme Court held in this particular judgment, what they said is, this Karnataka High Court exceeded its writ jurisdiction, preempting the statutory process by injecting itself before the RP report and adjudicating under Section 100 comments. It reaffirmed that existence of debt or waiver of a guarantee is a mixed question of fact and law. It's nothing to do with, see, 226 is for absolute, justice, right? If there is something is happening, if there is, body has to be bring those kind of jurisdictions, it should be utilized, not for, where there is a mixed question of fact and law. 226 should not have been invoked in such case. They squarely, and because this is, see, NCLT is a specialized court which only deals with that. So they are very sure that it's squarely within the AA's remit and not the High Court's early inquest. Consequently, Supreme Court set aside High Court's order. They restored the proceeding before the NCLT, starting from the RP appointment stage. Now, see, High Court is not a directing authority to NCLT. But if High Courts give a order, how does NCLTs don't follow it? So this is still a lacuna, I guess, in our code. It does not clearly bar, because if it clearly bars, then it will be challenged. So right now the situation is, in so many judgments, Supreme Court has said that High Courts, please don't get into these kind of issues unnecessarily. Remember yesterday we have learned a case where RPs are held to be public servants again, right? By Madras High Court. And Delhi High Court said no. So those things are still happening, but that is fine. That's a question of law. That's not a question of fact. There, if High Courts are getting into picture, it is still understandable. But guarantee, invoking, non-invoking, properly invoking, all these things, why do High Courts have to get into picture? So here, Supreme Court was very clear. Please don't get into this. Judgment reinforces judicial restraint. High Courts should not disrupt the IBC structured insolvency process unless some, jurisdictional infractions are there, be it Chennai should not have ever happened. It should only happen in, let's say, Guwahati. In such cases where there's a question of law, then you get into the picture. Otherwise, don't get into the picture. So it upholds the statutory hierarchy and phased approach of IBC, preserving the distinct roles of RPs, AAs, and High Courts as SAT. Fine. I don't know what is the takeaway in that. So I don't know if you have something you can add. Otherwise, we'll come to our question. So next question is next case law is Kirtan Kumar Upadhyay. This was again in NCLT Chennai bench on 19th of March. Here we will be discussing about a threshold. Now, are you aware of this case? Anyone? What is the threshold limit in PG cases? Anyone is aware? Section 78, 79. Suppose the personal insolvency starts, if not the personal insolvency to corporate debtor, personal insolvency per se. You know what is the minimum default which is required as per the code? Odaji, any idea? We can see you, but
Not
not hear you.
not under any case, sir. Personal guarantor.
No,
It's
so Maiji, we
1,000
have
rupees.
how much, sir?
1,000.
Correct, sir. So 1,000 rupees is the default which is supposed to be there for PG, for the personal guarantor. Oh, sorry, for the individual insolvency. So the issue was whether for PG to CD, you need 1,000 default or 10,000 or 10 lakh or 1 crore, like in CIRP. So is it clearly mentioned anywhere? It is not clearly mentioned anywhere in the code. It does not say that PG to CDs are a different class who shall be treated at par with the CD default. But having said that, if let's say you can take a PG to CD for 1,000 rupees, then you can take all that guarantors, isn't it? Then CIRP initiation has no meaning. So the issue which was, which was pending, and in my view, I think it is still pending, sir. It's not very clear. Right now, they say what the judgment says. This application was filed under 94(1). 94 is when you are going yourself. It's like section 10, right? Is filed by the personal guarantor, Mr. Kirtan Kumar Upadhyay, to initiate insolvency process against himself. CD had taken a loan of 75 lakh and applicant provided personal guarantee. Creditor, through the letter invoking guarantee, had demanded the amount of 75 lakh. So, question here is, what is the threshold? Simple question, right? IBC code classifies individuals into 3 classes. PG to CD, partnership and proprietorship firms, and other individuals, right? So right now, only PG to CD is there, correct? Right now, partnership is not there, proprietorship is not there, and obviously other individuals is also not. Now, this we have just learned, 1/12/2029. First one is there. Thus, it goes without saying, this is the decision. Huh? I don't know why they say without saying, huh? That the threshold limit to invoke 94/95 shall be same as is with respect to the CD under section 4. That is 1 crore. In the present case, default amount is less than 1 crore. Therefore, applicant does not meet the threshold to maintain the application. Right? Now, how many of you do agree with this order? Any viewpoint on this? Should it be 1 crore only? There is a whole one-way traffic. I don't know. Am I so boring or? Okay. I guess CPRs me too. So here it says 1 crore, and that should be the threshold for the PG to CD. I think let's move on, sir. Don't have. Okay. So seventh case of the day, Anil Sayal versus Ajay Gupta and others. This is Enclad Principal Bench. Anil Sayal, I hope you know this case. Here, initiation was done under 94 due to failure of a repayment plan. It went into bankruptcy. Bankruptcy also, finished. There was auction, etc. So things kept on happening. This story is not really important whether he had 50% share in the flat, not flat, etc., right? Here the main question was section 138, section 138 not of in check bouncing, but 138 of our discharge. See, in PG to CD there are two discharge. So in CIRP, what is the discharge? Resolution plan is successful, correct? You hand over to new person. Or second way is you do the liquidation and then finally dissolution under 54. There are two types of discharge, correct? In so I'm using the word discharge, but I hope you get the meaning, right? In personal insolvency, we have two types of discharging the person under discharging the liabilities. First is under 119. 119 is the personal guarantor discharge. And then we have a discharge under 138, which is the bankrupt. The person who has been adjudged as bankrupt. See, you can't kill the person, right? In dissolution, we kill the company. We say this person is no more. This juristic person is no more. But an individual you cannot kill, right? For debts, you can't kill people. Since we cannot kill the people, we have to let them go at some stage. So what is that stage? As per section 38(1), the stage is 1 year from the date of BCD. So bankruptcy commencement date, 1 year you have to let go. And second one is, if before 1 year you want to let that person go, it's fine, right? So this person, he filed an application to what you call NCLT, saying that I should be allowed to go because 138 is very clear. I should be allowed to go. What happened? NCLT said, if the law is so clear, law is also clear on a fact that only RP can file it. Right? Only an RP has the authority. Let me read you what 138 actually says. Okay. 138 says, the bankruptcy trustee shall apply to the AA for a discharge order on the expiry of 1 year from the BCD. Now they said, fine, 1 year is there, but you cannot file it. Only a bankruptcy trustee can file it. And who will instruct bankruptcy trustee? What happens if bankruptcy trustee does not file it then? So the question was whether the bankrupt can file an application for discharge if the bankruptcy trustee fails to act on the deadline. What happens? So NCLT said, no, you cannot come. Your locus is not there. Request the bankruptcy trustee. He will ask the COC, and if he feels, he will file it. So rejected. When they reject it, he will go to Enclad. What Enclad said is, can he file or not? Enclad said, statutory obligation on trustee. Section 138(1) mandates that the bankruptcy trustee shall submit a discharge application either after 1 year from the BCD or within 7 days of COC approval for completion. They say this duty is not eligible. It can't be postponed, etc., or some other reason. bankrupts locus in absence of trustees' action. Suppose trustee is not doing it, then what? If this person is not doing, highlighting the trustees inaction for over 2 years, tribunal held that the bankrupt has the right to inform the NCLT when statutory timelines are neglected. And rejection by NCLT was unsustainable. Tribunal find that the rejection by NCLT is unjustified, especially given the trustee's failure to act and the absence of credible evidence that granting discharge would disrupt the process. I mean, this is unnecessary because whatever he can disrupt, he will disrupt any which ways. Here, the NCLAT allowed the appeal, directed the trustee to file discharge application, and instructed the NCLT to decide. Once this order has come, after that, I also have filed a 138. Same day, there were 138 listed. Now, suddenly, all bankruptcy trustees, because 1 year has gone, now they are filing those application instead of waiting for COC's direction or something else to happen, and they are letting the discharge go. So, as a BT, if you are acting as a BT, do not hold it for any other reason, because now NCLAT directions are very clear. 1 year, unless you have a threat that this person is going to come and kill me, then you don't do it. Otherwise, it's your liability, or it's a non-delegable thing, right? You cannot remove it. It has to be done by the RP or the bankruptcy trustee. Fine. This was our case of Anil Sayal versus it has attained finality, because why will somebody go and challenge this one as of now? So nobody has challenged it. It has attained finality. There's another case, new case coming, Saranga Anil Kumar Agarwal. This case was also discussed heavily, where so this is more of a case which is akin to that 138, whether other liabilities can be done or not. So on 4th March, this case was decided. Here, the appellant, a real estate developer, was penalized by NCDRC, and 27 penalties, different penalties were there for failing to deliver residential units. Insolvency proceedings were initiated under 95, which triggered an interim moratorium under 96. This appellant, that means our developer must be, sought a stay on NCDRC execution proceedings under Section 27, arguing that the moratorium should apply. NCDRC said no, moratorium will not apply. It held that penalties under consumer laws are regulatory, they are not debts, and in personal insolvency, only debts are covered. Penalties, etc., are excluded debts, and those excluded debts are not covered. Hence, we will continue. Obviously, what will happen? Against NCDRC, you will approach higher court, right? So, issue was nature of NCDRC penalties. Are they debt recovery or they are punitive in nature? So, punitive versus criminal proceedings was discussed. Do penalties under consumer law fall within the moratorium scope? Section 96 and 14 were also discussed, where distinction between interim, which is in PG case, and comprehensive corporate moratorium was discussed. Limit of Section 96 protection, right? See, 14 is absolute, right? And nobody can touch you in any manner. Is the same protection for 96? That was discussed. Again, 138, Consumer Protection Act 27. Here also it differentiated negotiable instrument and consumer protection penalties. And obviously, IBC objective was discussed. What the decision? Obviously, we are more interested in decision. Supreme Court upheld that NCDRC order unequivocally confirming that regulatory penalties under Consumer Protection Act are not debts which are as defined under IBC. And thus they are not subject to interim audit. They upheld the view of NCTRs. The clearly distinction was drawn between civil recovery proceedings. If there is civil recovery, there will be moratorium. Suppose you had DRT or whatever is happening, or let's say surfacey actions were pending, those will be stayed. And regulatory or punitive actions which remain enforceable despite insolvency process. The moratorium under 96, designed for personal insolvencies or guarantors, is narrower in scope than the broader corporate moratorium, and hence there is no blanket protection available. Penalties in questions held to be excluded debts and I hope you're aware of excluded debts and excluded assets, right? So excluded assets is which cannot be taken over by the RP or PG, RP or the BT, and excluded debts are those debts which cannot be removed or vanished under this law, like student loan, like maintenance, if there is any. So maintenance is also a kind of penalty. Same way, a penalty of NCDRC, they said, should be excluded debt, and it is included in this, which includes fine, damages, statutory penalties. Court emphasized that the public policy underpinning consumer protection, allowing moratorium, if they would have allowed, they're saying, what in case we allow, what happens? Then to shield such penalty would enable developers to evade accountability by triggering insolvency, and it would have defeated every other purpose. This IBC would have taken over everything if even this is allowed. So they said then, then we might have to close RERA and we'll have to close NCDRC. Then there is no meaning of those companies if this is allowed. So it was not. Name of the case in this case is Saranga Anil Kumar Agarwal. So I think an important case law again. After this, two more cases left for the day today. Nasir Ahmed versus Ravindra Pellayur. Again, we'll go to NCLAT Chennai. See, for PG cases, there are a lot of cases in South India, like especially Hyderabad, NCLT, and Chennai had pretty decent number of PG cases in the beginning, because most of these were uh, not real estate, but hydro projects or infrastructure projects. So those cases were admitted, like Athena, MD, or Sikkim Hydro, those kind of Gammon, those kind of cases were lot in Hyderabad. Gati infrastructure, all those are in Hyderabad. So those were admitted. I think that time Hyderabad was pretty much active. So they had admitted, and that stage has come. Here in Nasir Ahmed versus Ravindra Belur, what happened is this was about see our code. If as a RP you might have seen, our code nowhere says that so our code is so innocent. It says whenever you give a chance to a personal guarantor, they will submit a plan. Isn't it? That is the assumption. Nowhere. You read 102, 103, 105 till 114. There is nowhere it says that what if they don't give a plan? Our code is so cute, so innocent. They assume that no, they will give. If you give them an opportunity, they will give. What if they don't give is not even envisaged? And there is no amendment also for last 7 years, 6 years. Nothing has come on this. So if they do not give a plan, then what happens? This case deals on that matter. So appellant as personal guarantor, I mean, this is obviously about the appellant. Personal insolvency was initiated under 95, leading to appointment. RP requested payment plan. Guarantor failed to submit any payment plan. Reminders were sent, extensions were given, but no plan was given. So if no plan is coming, what do? You file a report. You file a report under 106, and 106 you say, sir, I have not. See, 106 also has a time limit. Correct? It can't be endless. So since it has time limit, then you have to file under 112, whether plan had come, whether you voted, not voted. That I mean, if there is no plan, what do you vote on? And what do you discuss? Nothing. So NCLT treated this as a deemed rejection of the repayment plan. They said if you have not filed, then it is as good as rejection. And if it is rejected, then section 114 is there, which allows for you go for bankruptcy. What else, right? If somebody is not coming forward, you go to the next stage. It is as good as putting somebody as ex parte. You gave them sufficient chance. If they do not come forward, what do? You proceed ex parte. So here, whether a personal guarantor's failure to submit a repayment plan within the stipulated time frame, whether it's a trigger, whether it triggers automatic rejection and consequently bankruptcy can be followed, or and whether this decision should be interfered or not. Obviously, we know the answer. NCLAT dismissed all such appeals, and the finding was that failure to submit the repayment plan within the prescribed timeline leads to automatic rejection under 114. Such deemed rejection empowers the creditor to initiate bankruptcy proceedings and under 115, and they can file, 121. 121 says anyone can file, and 122, 123, same like 94, 95, right? So 124 expressly permits bankruptcy application following if it has failed within 90 days, you have to go there. And I hope all of you are aware that if 90 days is passed, then you cannot go for bankruptcy. You will have to restart your personal insolvency and then only can come for bankruptcy. Right? Any question in this so far or continue? No? Okay, we'll continue that. Okay, last case of the day is Paresh Rastogi and others versus Omkara Asset Reconstruction. This is a case in NCLAT, New Delhi, around 4 months back, right? March. So in this case, what happened is, this was I don't know whether it's really related to our RPs or not, but it's definitely related to the advocate friends there who are filing for banks or something like that. Or maybe, under 99, you might have to look into it. So here, the corporate debtor, a borrower of approximately 90 crore, defaulting on the loan, and irrevocable personal guarantees which were executed, they were, started. Now, this Omkara, the FC, Omkara Asset Reconstruction ARC, they sent a recall notice, invocation notice, and a demand notice. So, see, whenever it's ARC, they say, we will send everything. Right? You remember just now we learned SBI only sent a demand notice, did not send invocation. So I think the, ARCs are little more smarter than that. They send everything. They send recall notice, invocation notice, demand notice, सब कुछ लगा देंगे. Now, these notices were sent to the last known addresses as per the guarantee deed. Obviously, guarantors will say कि हमें कभी मिले ही नहीं, right? If they have never got it, how can you initiate? Now, we also know, courts also know that many of the time people avoid the delivery, avoid the receipt of the letters. Relying on the guarantor's failure to repay within 14 days, Omkara filed application under 95, and obviously NCLT admitted the application. The moment applications are admitted, we all know that all these guarantors, they run to NCLAT. Obviously, they'll challenge what they will say. we never received it. How can you even start it? Now NCLAT will have to design the issue. Issue was service to the last known address valid under 95 or not? Correct? We don't know right now where is. See, at times the problem is when these guarantees were executed, we just now you saw, right? In 2011, 2005. So after 20 years, the person must have changed their home, right? Might have changed their home very easily. And maybe you're not aware of that. So if you're not aware, what do you do? How do you search the person? You can only send a letter to their last known address. And all the banks, they say KYC we do every year. We do, all your bank accounts every 2 years they have to take the KYC of every person, even if they have 100 rupees in the account, they will insist for KYC, updated KYC, right? So suppose you don't have, and you only have a last known address when the guarantee was signed. Will this be applicable? Can insolvency proceedings be initiated against both the corporate borrower and the personal guarantor simultaneously? And obviously, this last answer, we are all very clear so far, but in this case, again, there is. Here, decision was notice served was valid. Tribunal upheld that sending notice to the last known address as agreed in the guaranteed deed constitutes valid service, even if the guarantor claims not received. Now, class 22, obviously, normally they write in the deed that whatever is written here, we will serve it. Simultaneous proceedings are also allowed. I think this, we all know that these are co-extensive liabilities and there is no bar on proceeding at both. Only catch here is that if you have already done some recovery at A, then you have to reduce it and inform that RP that I have already got so much money, my claim might be reduced by so and so. As a result, the appeal was dismissed, NCLT order admitting PIRP, and it goes up. So I guess that's what I had for the day today. 12 case laws. Any question if anybody has, please raise. If not, then we'll call Anjali ji. No?
डिटेल्स भेज देना एक बार और भी thoroughly पढ़ लेंगे.
Sir, sorry, your voice is not clear, sir.
सर मैंने कहा था कि जो ये जजमेंट है इनकी एक बार लिस्ट हमें भेज देना ताकि हम इनको दोबारा भी एक बार दोबारा रिवाइज कर लेंगे, पढ़ लेंगे. अच्छी थी आपकी प्रेजेंटेशन.
Okay. Let me do one thing. If I can share it here, I can share it right away. This might help. Anjali ji, should I share you or can I share here itself? What do you want? I think she is also not here today. Okay.
अंजलि जी भी नॉन रिस्पॉन्सिव हो गई हैं सर हमारे साथ रह के.
हाँ सर, आपका तो समझ आता है, उनका नहीं आता. So, it's been 8 years now doing this insolvencies. And so how many of you are actually handling PG cases? Anyone here who is
Not me, sir.
not me? तो फिर अभी आपको पता नहीं चलेगा सर. So if people are here, they, in one of my cases at PG, they wrote one line. They just said, we are exploring our appeal. That's all. Nothing else. Nothing. This was one line. And for that one line, they made me go around for 2 years at NCLAT. But obviously, then Dilip Juarjika came and it was stayed. They said, we have never said we are not submitting. We only said we are exploring this option. RP has come to you saying we don't want to submit. When did we say we don't want to submit? And then obviously I had to give all these that, boss, if you are exploring other option, I am requesting you for a repayment plan. You are not giving me repayment plan. What does that mean? It only means that, right? And it was not so easy. They went to Anklet. You go to Anklet, 6 months are already dead. And if your appeal is pending, then NCLT will not take a decision on those things. So, and obviously they're enjoying the moratorium any which ways. So that interim moratorium goes on. So even one line and it gets stuck somewhere. So PG cases are interesting. Only thing is in PG, in my views, are you don't have to be. I think yesterday also I used the word. You don't have to be Rambo. Just stick to what is mentioned. And I think let me see.
But there
Yes.
is no fee prescribed by IPBI for personal guarantor.
There is no fees prescribed, sir. Yes. In fact, like liquidation, there is a schedule, right? In liquidation, as liquidator, there is no minimum fees. So as
Yes,
liquidator, there is a schedule.
yes,
Same
yes.
way, in bankruptcy, there is a schedule, almost similar. But there is no minimum fees fixed as in CIRP, which is fixed. And
No
since
monthly, no monthly fee.
no monthly, sir. And
So
unluckily,
discussion,
because that monthly is not fixed, I already told you, I personally know people who are working at 75,000 lump sum fees for the entire case. 15,000 also some people have taken per month. So those kind of cases are also there as well. And people say that, recovery is not possible. In one of my case, we have recovered 100% in a PG matter, Pioneer Urban. So there's a newspaper, Pioneer newspaper, if somebody is aware. So
Yes, yes.
we have recovered 100% also. It's not that it can't be done, but I mean, my view as an RP is don't work for 10, 15,000, so let it go. So yes, if I have shared both the PPTs here, yesterday's and today's. If someone wants to download, please download. And I hope all your attendance is also done. So since
How
Anjali
to
is not
download it, sir?
here,
From
sorry sir,
it.
your voice, I can hear somebody is trying to say something, but someone is saying something, or we can opt to close.
so a discussion paper was brought in for fees of PG cases,
Yes, yes.
but the level of fees was so bad that maybe a peon or a watchman would have a higher salary. So anyway, that's but there
Devangji,
was a paper.
we actually use this word that, they call you chairman of the committee of creditors, and they expect you to take the salary of the words you rightly use. So yes, that problem is there, sir. And that is why we say let it be a little some benchmark that okay, fine, below this it will not go. Sir, even if what Devangji was saying, no, it was so minuscule. Even that one, if it is fixed, is fine. Some bankers are even trying to go further down when there is no minimum. Now, what do you do in such cases? So at least it will have help those cases where we don't have to do, come back unnecessary. Okay, I guess if no one has any other comments or any question, if you have, where so I'm advocate in some 7, 8 PG matters and my own PG cases and bankruptcy. If you have any question you would like to ask, please feel free. Or if no question, then we can conclude it for the day. I don't know if Anjali has. Let me call Anjali ji once. Just
Shall we conclude, sir?
Anjali ji, we are trying to conclude it. So if you are here, we'd like to close our session. We are
Okay. Thank you very much,
we have
sir.
done our work.
Thank you very much, sir, for giving your valuable time and sharing your experience in PG cases and CIRP cases.
I've
And
shared the
different
PPTs also here on the chat box with everyone. So we have done.
Okay.
Yeah. So
Thank you.
hope to see you guys again. And we are based in Delhi. If any one of you based in Delhi, please do connect. I would love to interact. Good days.
Thank you very much, sir. Thank you.
Good days.